Good morning, everyone. My name is Shazia Khan, and the unit we'll be doing today is Industrial and Intellectual Property Law. And we're doing Learning Outcome 3 today, which is to understand the different forms of industrial property rights. Firstly, I'm just going to summarise what we did in the last Learning Outcome, which is Learning Outcome 2, which was to understand the associated laws and procedures relating to copyright and trademark laws and the impact of jurisprudence of EU intellectual property law on the UK. So we went firstly into looking at an introduction on what intellectual property is. We looked at the elements of intellectual property, and we looked at firstly looking at copyright and trademark laws. We looked at the difference between each one, the importance and the laws that apply to that in regards to protecting individuals' rights. We looked at trademark laws, how they protect brand names, logos, slogans, and other identifiers. We also looked at copyright and trademark enforcement, so that the remedies available can be things like injunctions, monetary damages, so any form of compensation, and seizure of infringing goods. We then went on to look at intellectual enforcement of intellectual property to enforce issues globally as well. We then went to look at the impact of EU intellectual property law on the UK. So we looked at the directives such as the Copyright Directive and the Trademark Directive, which is there to harmonise intellectual property laws across EU law. We looked at the impact of Brexit on intellectual property, and we looked at the legal precedents in regards to the Court of Justice rulings on intellectual property. We also looked at challenges and consideration in regards to intellectual property across EU borders post-Brexit, because there was a lot of changes that were made in regards to that. We then went on to look at 2.1, which was to analyse the underlying principles of copyright and why copyright laws are so important within protecting intellectual property rights of creators, and why there's copyright have the exclusive right is the one of the creator. So we looked at that. We also went on to look at copyright laws in the UK, which are governed by the Copyright Designs and Patents Act 1988. And this legislation protects individuals in regards to the rights over their own works. We then went on to look at international copyright laws and looked at the Berne Convention and why that is the most important treaty in regards to copyright laws, and looks at copyright protection among different member countries. We also looked at the World Intellectual Property Organization, WIPO, and the Copyright Treaty, WCT, and also the Performances and Phonograms Treaty, WPPT, in regards to agreements against different states, or the enforcement of copyright protection in regards to that. We then went on to look at the comparison of UK and international copyright laws, and how they differ in regards to protecting an individual's work, but also the protection for works created under that jurisdiction. So whether it was in America, whether it was in the UK, whether it's Canada, how that comes about in regards to protecting individuals' rights. We then went on to look at the enforcement of copyright rights, and looked at, in the UK, we have the Intellectual Property Office, UK IPO, and they're the ones that play the pivotal role in guidance and supporting creators to enforce their rights. Internationally, copyright laws often collaboration through different treaties and agreements. So, because if each country has its own jurisdiction, you must follow the different treaties and agreements that are in place for that country, rather than using the same law in the UK. We then went on to look at 2.2, 2.4, which was to analyse the framework of trademark law as operated in the UK, Europe, and internationally, and looked at the importance of why trademark law is so important in protecting brands, also in protecting their distinctive symbols, names, and logos, and why that is so crucial, and why there needs to be trademark laws in place to protect businesses, but also safeguard intellectual property in the marketplace, and why that's so important. We then went on to look at trademark law in the UK, which is operated primarily under the Trademark Act 1994, and ensures that businesses can establish and protect their brand identity. We went then to look at trademark law in Europe, and we looked at how it's used through the EU trademark regulation, EU 2017-1001, and that was something that was established a single trademark known as the European Union Intellectual Property Office, EU IPO, providing businesses with the option to register EU trademarks, EU TMs, offer protection for all EU states. International trademark law, the Paris Convention for the Protection of Industrial Property, which we looked at in regards to international registration of trademarks. We then went on to look at the key elements of trademark law and things like, distinctiveness, registration, the use in commerce, infringement, enforcement. Then we looked at enforcement of trademark rights, how they can be enforced, and owners can enforce through civil litigation, seeking remedies such as injunctions, damages, and seizure of infringing goods, which we'll be looking more on in Learning Outcome 4. And then we looked at the importance of intellectual property protection within businesses. We then went on to look at 2.5, which looked at evaluating limits, enforcement, infringement of copyright and trademark. And we looked at there's laws and limitations and mechanisms of enforcement in place for limits of copyright and trademark protection, and how that is so important. We looked at civil and criminal enforcement. So both trademark and copyright owners have the right to enforce intellectual property through civil litigation. Legal ramifications, we looked at damages. Criminal can lead to fines and incarceration. We looked at fair competition and innovation. So we looked at how the copyright and trademark laws aim to protect the rights of the creators and businesses, because the laws have to be fair and in preventing practices such as imitating goods or copying brands and things. So we had to. It is really important due to societal interest to make sure that the laws are in place to protect individuals and that there's fair competition. So that was in regards to Learning Outcome 2. And now we're going to look at Learning Outcome 3 in regards to intellectual property rights. So the Learning Outcome 3 is to understand the different forms of industrial property rights and why they're so important. Assessment criteria is 3.1, which is critically analyse the justification for intellectual property. 3.2, analyse the law of industrial designs. 3.3, compare and contrast the UK national registered design right and an unregistered design right system. The indicative contents, so patents and utility models for inventions, industrial designs, trademarks and geographical indications, patent scope, rights, types, registration and applicable laws, and registered and unregistered system. So firstly, we're going to look at 3.1, which is to critically analyse the justifications for intellectual property. So what is the justification for intellectual property and why it's important to understand that? So the standard justification for intellectual property is ex ante, which is the goal of intellectual property is to influence behaviour, that occurs before the right comes into being. It is the prospect of intellectual property right that spurs creative incentives. So it's really important to understand that. Industrial intellectual property legislation is part of the wider body of law known as intellectual property, which is referred to as IP, which refers broadly to the creations of the human mind. Intellectual property rights protect the interests of innovators and creators by giving them rights over their creations. So if someone's created, for example, just an example is a ball that helps, stress ball, that is their creation. They are the creators and they have the rights over that creation. So it's really important to identify that they have that right and that is there. And if it's breached or, if there's any, issues around that, it's really important that it's protected. So they have that right to have that protection over their own products. The convention establishing the World Intellectual Property Organization 1967 does not seek to define intellectual property, but lists the following as protected by intellectual property rights. So it's things like which we referred to Learning Outcome 1 and 2, your literary, artistic, and scientific works, your performances of performing artists, photographs and broadcasts, inventions in all fields of human endeavor, scientific discoveries, industrial designs, trademarks, all other rights, intellectual property. So it's really the importance of intellectual property was first recognized in the Paris Convention for the protection of industrial property, which we looked at a little bit in Learning Outcome 2. So a really important case in regards to this is the case of the Advocate case, also known as Irwin Warnick, Townend and Sons Hull Limited. So a little bit of background to the case. So Irving Warnick, also known as the Advocate case, is a leading decision of the House of Lords that further developed the common law tort of extended passing off for the Commonwealth as originally established in the case of Bollinger and Costa Brava. The background to the case is that Warnick was one of the primary market producers of Dutch liquor made from a blend of hen egg yolks, aromatic spirits, sugar and brandy, which it sold under the name of Advocate. Townend produced a similar alcoholic drink by using egg and Cyprus wine, which it sold as Keeling's Old English Advocate. The court held that Townend was passing off their goods as those of Warnick. In applying the test for passing off, the court developed what is known as the extended tort of passing off, which included any situation where goodwill is likely to be injured by a misrepresentation. And Lord Diplock established 5 criteria for a claim of extended passing off in the case of, in this Advocate case. First one was there must be misrepresentation, which there was in Warnick's case. Secondly, that by a trader in the course of trade. Thirdly, to prospective customers or his or ultimate consumers of goods and services supplied by him. Fourthly, which is calculated to injure the business or goodwill or honor the trader, which in this case it was, and which causes, number 5, which causes actual damage to the business or goodwill of the trader bringing that action. So in this case, this includes deceit by a broker to intended clients or extreme buyers of his labour and products, which intended to determine another broker's business generosity, which causes actual harm to the dealer by bringing their activities. A person who sells goods that are appropriately depicted as being manufactured by a maker but are of low class or quality may undermine the producer's goodwill. Master Diplock defined passing off as number 1, deception. Number 2, made a broker through our exchange. Number 3, to prospective clients, to extreme buyers or his labour and products. And number 4, intended to harm another merchants, as we mentioned. And number 5, intended to harm the business. The question of whether the state should subsidise the cost of content creator, a legitimate right to exclude other forms from manifestation is a hotly debated issue in data morals. Protected innovation liberties have been harshly criticised for the last 30 years as advanced computerized data developments have broken off the connection between the expression of thoughts and traditional material-based media like books and magazines. Some fascinating features of scholarly material appear to compromise licensed innovation security. For example, the piece of scholarly content can be simultaneously appropriate by everyone on the planet without lowering the inventory of that content. The overall question of whether licensed innovation is supported differs from more specific issue of whether a particular licensed innovation law, which is intellectual property law, contrary to popular belief, a specific package of laws protecting licensed inventions. We now move on to analyze the law of industrial designs and what they are. So industrial designs are really important for any marketplace because as an increasing competitive marketplace, innovation and aesthetically appealing industrial designs are vital for businesses to stand out and establish this strong brand presence. The protection of these valuable assets through intellectual property law is crucial to maintain a competitive edge and prevent the unauthorized use of infringement, which happens quite a lot. Intellectual property law is crucial to maintain competitive edge and prevent any sort of, forms of infringement. Intellectual property law for industrial design dives into the world of intellectual property, focusing on safeguards necessary to protect. And there needs to be a lot of safeguards in place to protect individuals' rights, because the fact is that there are lots of issues of infringement, copying, imitation, and these elements that would breach industrial design rights. So industrial design rights are obviously there to protect serve to protect the visual appearance and aesthetics of a product, encompassing its contour, the shape, colours, patterns, and overall design. So within the realm of intellectual property law, these rights coexist with other intellectual property rights such as patents and trademarks, which protects a product's functionality and branding aspects. Industrial design rights vary across different jurisdictions. So different laws are in place in different jurisdictions. So it's crucial to kind of understand the specific legal frameworks of different countries in which you seek that kind of protection. And looking at the UK one, in the UK, there's classified rights as registered and unregistered, which we'll look a little bit at later. So a crucial aspect of design law is novelty. For a design to claim protection under design law, it ought to be new, meaning it should not be an exact copy of a previously known design. So for example, if a new smartphone design is brought to the market, it must not exactly replicate existing designs. For example, it shouldn't replicate anything from Apple or Samsung. Any similarities should be accidental or inconsequential for it to gain a protection under design right. Intellectual property laws is integral into the world of design. It concerns the right of creators over their inventions or expressions. The law protecting industrial design stand as an integral pillars that safeguard, recognise and elevate the value of innovative design contributions, and these laws provide vital protection against any sort of imitation, preserving the uniqueness of a product's and aesthetic appeal. So in today's highly competitive market, industrial design rights are essential tools for businesses of all sizes to protect any sort of products they've designed, any sort of innovations, and provide, so there are certain elements of that are protected. So it's really important that these rights are protected. And it's really important that you have that law in place to challenge these rights. Uh, you know, um, so surprisingly, a limited number of humans can consume a material element simultaneously. So using material components, as we mentioned, is competitive, while using scholarly elements is non-competitive. The distinction is sometimes assumed to impact the intellectual property's legitimacy. It is prudent to safeguard material assets because they may appropriately by a small group of people at any time. So protecting your rights is really important. You need to make sure that your rights are protected and that you, as a creator, have a legal protection in place. The strongest argument for legitimizing material property rights don't rely on the fact that materials are scarce and competitive. So most deontological legitimization for property freedoms are based on statements about humans managing specific material attributes. For example, a lock-in claim will highlight a party's anticipation of work in some material item to which no one else has prior claims as leading as property directly in that piece. Similarly, the potential scarce and revilous material elements plays no role in the consequential list arguments for material property rights for security. Today's plan properly will ensure the three-dimensional or two-dimensional plan of an item to the extent that it satisfies curiosity and individuality. This law defines configuration as the exterior appearance of an item or component of an item as portrayed as its visible shape, forms. For this law, an item of product of industry handcrafted, the requirement may protect the individual. So it's really important that, there are differences in place to protect individuals because, the whole point of it is that, there are cases in place, quite popular cases that there were issues with design laws that were an example that I could give you of quite a famous case that looked at which I mentioned before, is there's a famous case of Apple and Samsung where the tussle was over the design of smartphones and tablets. So Apple claimed that Samsung had copied its designs, including the rectangle shape with rounded corners. However, the court held that these features were smartphone designs and ruled in favor of Samsung. So the case emphasized here in this case, significant point of functional features cannot be protected under, design laws. Another really good example is the example of a highly publicized case is the case of Trunky against Kiddie that took place in the UK. Here, the designer of Trunky, which is a ride-on suitcase for children, sued the creators of Kiddie Case for design infringement. The court, however, found sufficient differences between the two designs and ruled in favor of Kiddie. This case shows how minute differences in design can influence the court's decision on design infringement cases. So it's really important to make sure that, that the protection of the law is, if for your item, for your invention, that there are laws in place, and it's a historical thing that developed over centuries. It's not just something that developed now, it's something that developed historically, and they were, trying to protect individuals' rights. It was traced back to Industrial Revolution time, where the first laws enacted began as a governmental response to like piracy of British designs for foreign manufacturers. So it's something that's a historical thing rather than something that was just developed today. So the issue is unique with last option guarantee and illustration cases require the support of other regularization cases to adequately help. Occasionally, a sensible gap exists between realities and values. To establish that intellectual property insurance is bad, one must show that that violates some morally guaranteed interest, which is standardized guarantee. For example, shape or beautification are protected under UK plan law. If a plan fits certain criteria, the owner may be eligible for unregistered plan right. This is program licensed invention security that protects unique non-standard plans from being copied. Whether it's a botanical or ornamental example, a computer symbol, or the specific state of an item and its packaging, plans are secured to ensure the owner receives a fair reward for their efforts. And this was in the Boca 2020. Aside from unregistered plan rights, creators can acquire a higher level of certainty by enrolling the plan within the UK Designs Registry. So it's really important, you know, the issue around protection. You know, it needs to be that there needs to be in place laws in place to protect the individual rights. You know, if you know, and there are remedies in place. So if a design rights is infringed, which is quite good in regards to this, by someone who is not given the right to produce a certain product or design, then the registered proprietor of that design has the ability to take action of infringement. This action normally taken in the form of remedies, which we'll be discussing more in Learning Outcome 4. So there are, you know, if a design has been infringed, the court can award the plaintiff aggravated damages. Now we're going to move on to 3.3, which is compare and contrast the UK law, national registered design right and an unregistered design right. So in the UK, there are design rights can be classified into two categories, which is registered design rights and unregistered design rights. Registered designs grant an exclusive right to use and exploit the design for up to 25 years, subject to the renewal every 5 years. Unregistered rights offer automatic protection, but are more limited in scope, lasting 15 years from the date of creation or 10 years from the first marketing of the design, whichever is earlier. So to obtain registered design rights, designers or businesses must follow a registration process with the relevant intellectual property office. So for example, in the UK, it would be the UK Intellectual Property Office. This typically, the process involves like following steps, things like eligibility assessment. So whether you can determine if your design meets the eligibility criteria for registration, which includes things like novelty, individual character, and non-contradiction with public policy or morality. Another element and a step that needs to be considered is design representation. So prepare accurate and clear graphical illustrations of your design, providing multitude views like the front, side, and the perspective that showcase the distinctive visual features of the design. Thirdly, the application submission. Here you complete and submit the registration application through an examination of the application, ensuring it meets formal requirements for registration. And finally, the step is publication and registration. If the application is accepted, the design will be published in the design register, granting the owner exclusive rights of use of enforcement. And this is for securing registered design right. For unregistered design rights for protection, rights provide automatic protection without the need for registration. However, these rights have certain limitations in comparison to the registered counterparts. So number one, restricted geographical coverage. So unregistered design rights generally only offer protection within the country of creation. So if it was created in the UK, it would only offer that protection in the UK. If it was created in America, it would only offer that protection in America. Whereas a registered design can extend protection to multiple jurisdictions. So unregistered don't have the right to do it in all multiple jurisdictions, but registered do. Secondly, the proof of ownership. Since unregistered design rights are automatically granted, proving ownership during an infringement dispute can be challenging. So it's essential to maintain relevant documentation of design creation and development or to demonstrate your ownership. So you must have everything in place to prove that you are the owner, because it's really hard for unregistered designs. Thirdly, limited enforcement options. So enforcing unregistered design rights may be more difficult than enforcing registered design rights. So as it requires the owner to prove copying or misappropriation of their design and establish ownership. Despite limitations, unregistered design rights can still be valuable in deterring infringement and safeguarding the creator's interests to an extent. So what's the difference between registered and unregistered designs? So the purpose of protecting your design is to stop others from copying it or encroaching too closely with their own designs. The protection of your design will be based on its aesthetic features, as we mentioned earlier, including things like, the appearance, the physical shape, the configuration, or the decoration. There are two types of design protection that exist, and we mentioned registered design protection and data design protection. So just about enforcing industrial design rights. Protecting industrial designs, including intellectual property laws, involves not only securing the rights to be as actively enforcing them against unauthorized users and infringers. Key strategies for enforcement include monitoring the market. So keeping an eye on the market, both online and offline, to identify any sort of possible or potential instances of design infringements. Cease and detest letters, which we will be looking a lot more at in regards to learning outcome 4. Legal action and remedies. So, navigating the complexities of intellectual property law for industrial designs necessities. We could, critical insights and updates, partnering, looking at the registration processes, safeguarding any sort of aesthetic and functional aspects relies on, you've got to have that deep understanding of intellectual property to do that. So we're looking at registered designs protection and design right protection. So in the UK, European Union, and many territories of the world allow registration of designs. A registered design protects the overall visual appearance, shape, and decoration of a product or a part of the product, as we mentioned. Once a design is registered, the owner can take legal action if someone, as we mentioned earlier, copied it without having to prove ownership or creation, as the registration itself provides evidence of this. Registration gives you a 25-year monopoly for the design for a relatively low cost. So this design can be licensed and sold by you. A registered design is easier to enforce than a unregistered design, as we mentioned earlier, as no proof of intentional copying is required, whereas registered designs are often seen as a stronger form deterrent to would-be infringers. The registration of a design gives the registered design owners the exclusive right to use the design, and any design which does not produce an informed user and different overall impression. To qualify for a registered design in the UK, the design must be new, as we mentioned earlier, and have individual character. A design would be considered new if it was published or made public before the date and design application was filed. When we're looking at a little bit more on unregistered designs, a degree of protection exists for designs that are not registered, as I mentioned earlier. This protection arises automatically, providing the design fulfills the certain criteria. So it's really important, and it is really important that you can challenge both, registered, more registered than unregistered design. But, there is, the right for you to challenge that. A registered design, like we said, has a legal right then itself because you've got proof, whereas an unregistered design right only exists if there's evidence to show that. So, there needs to be evidence in place in regards to both registered and unregistered unregistered design rights. So the Hague system for international registration of industrial designs is a streamlined regime for applying for registered design protection in more than one country through one application via the World Intellectual Property Office, the WIPO, which we mentioned earlier in Learning Outcome 2. Alternatively, you can file separate design applications in individual territories in which you want to register. So the advantages of the Hague system are that you only need to file one application and you can manage the registrations through the WIPO. However, the timescales may vary from national applications. Protection is granted to a designation of an international application 6 months after publication or 12 months after publication. So just in design rights provide, very useful method of protecting your work, which can subsist independently or alongside copyright and trademarks. So there are protections in place for them. So to conclude now, unregistered plan freedoms might be difficult to show and have shorter use durations. Despite this, some organizations prefer unregistered plans because they are more expensive and take longer to develop new products. In the fashion industry, for example, the timescale of realistic usage for things and plans might extend months, even weeks, due to the speed with which style brands move, because new brands come into place, new plans move on to new plans, and the cost of enlisting their entire range of plans for comprehensive insurance. Unregistered plans are still necessary. However, an enrolled configuration is bound to an obstruction as to the enrolled plan right. Holder does not need to show encroachment. It's also an easy right to sell or grant to a big outsider. So as the world of fashion, the example we use is changing all the time. Brands are changing and moving on, so there needs to be in place, plans in place because of the changes that are going on quite quickly. It's easy to get people involved from the outside. So now we've finished learning outcome 3. These are the references that have been used for Learning Outcome 3, which can help you towards completing your assignments. So a lot of these will be on Moodle for you as ebooks that you can refer to and use in regards to completing your assignments. So there's loads of resources there. The books are there. There's also some good journal articles out there that you could refer to and read around in your own time. Also, there are lots of ebooks, as I've mentioned, on Moodle and any sort of additional reading that you can do. If you have any questions around today's session or any of the session, please email learnerwork@ukvarsity.co.uk. And if you have any questions generally, please also email learnerwork@ukvarsity.uk. The next session we'll be doing is Learning Outcome 4, and then you will have the assignment discussion session, which will be after Learning Outcome 4, and that will help you towards completing the assignment, but will give you guidance and support in regards to doing the assignment. Thank you for attending today's session on Learning Outcome 3. I will see you in the next Learning Outcome, which is Learning Outcome 4. Thank you.